last regular session of this hearing on January 22, 2013, both the objector and the candidate rested the presentation of their respective cases. They jointly sought leave to file memorandum of law and arguments for the consideration of the board, and they each did so in a timely fashion. I have met with each member of the electoral board individually in an attempt to answer or clarify any legal questions that each may have presented. I am particularly impressed that all three members of the electoral board have thoroughly reviewed all of the documents presented in the course of this hearing and the two memoranda of law and arguments that were presented by the respective parties. I know that each member of the electoral board took their duties and responsibilities with regard to this matter very seriously. Today's meeting will only be for the purpose of considering a decision in order with regard to the verified objector's petition. No further testimony will be presented, and no further arguments or comments from the respective attorneys or parties will be presented unless in response to a question from a member of the electoral board. One other issue to address before turning over to the electoral board. Just today, Ms. Williams, you filed a document labeled motion to strike, and Ms. Williams, yours was labeled candidate's motion to strike, and Mr. Emmons, you filed a response labeled motion to strike. Oh, I get it. I didn't have time to review yours, Mr. Emmons. Okay. But essentially, I'm told that with the filing of those two documents, the issue raised by you, Ms. Williams, is now moot. Is that correct?
As long as the requested paragraph is stricken from Mr. Emmons' memorandum of law, yes.
And his motion to strike is to strike that paragraph?
Yes, that's correct.
In question, and I see no reason not to allow his motion to strike, therefore making your motion moot, and with that, that will be the order of the electoral board unless there's any question. So ordered. In talking with the individual members of the board, I have attempted to formulate a proposed decision and order for their consideration. We are now at the point where the members of the board should present their thoughts and, to the extent necessary, debate the issues presented in this hearing. Who would like to go first in stating his or her position?
I have a motion, and I have carefully reviewed all of the testimony and the exhibits that were presented in the course of the hearing in this matter. I've read all the laws and cases that were presented. I met with our attorney, Mr. Shrimp, and shared with him my opinions in this matter. To me, I believe we are required to do our best to follow the law. Individually, we may not agree with the law, but it is our obligation to abide to the letter of the law. We were required to determine if Mr. Walker was eligible to be a candidate for mayor as of December 17, 2012. He was not eligible to be a candidate if on December 17, 2012, he was in arrears or delinquent in any matter of his obligations to the City of Alton. I believe, based on the evidence presented to us, it is clear that the sewer service fees and the refuge fees for the services provided by the City of Alton to 1000 Marie Avenue, Alton, Illinois, were delinquent on December 17, 2012. Some fees have been delinquent not for a considerable amount of time. As the owner of 1000 Marie Avenue, Mr. Walker was responsible for the timely payment of the sewer service fees and refuge fees of the City of Alton for the services provided to his property at 1000 Marie Avenue, Alton, Illinois. I discussed with Mr. Shrimp the various issues raised by Mr. Walker in his attempt to negate his responsibility for the payment of the sewer service fees and refuge fees that were delinquent with regard to city services provided to 1000 Marie Avenue as of December 17, 2012. Mr. Shrimp prepared a proposed order addressing those various arguments made by Mr. Walker, and I have concluded that Mr. Walker's various arguments do not negate the fact that he was responsible for fees that were in arrears to the City of Alton December 17, 2012. Accordingly, I move that we adopt the decision and order prepared by Mr. Shrimp as the decision and order of this electoral board, which concludes by finding that the name of Brant T. Walker shall be stricken from the ballot by the appropriate election officials with regard to the election to be held April 9, 2013.
Is there a second on that motion? Motion by Mr. Drake.
I did provide a copy of the proposed order that Mrs. Bowles refers to each of the members of the board individually. They've had an opportunity to review that. Are there any questions or comments from members of the board before a roll call?
I have none.
I have none.
If none, would you please call the roll?
Fleming.
Aye.
Brake.
Aye.
Bowles. 3 ayes, no nays, no absent.
The motion having been passed, I will ask the members of the electoral board to each sign at least 4 originals of the decision and order, which you have just approved. After the originals are signed, I would like to place on the record 1 original signed decision and order, and we will then deliver originals to both Mr. Emmons and Ms. Williams on behalf of Mr. Walker. Is that acceptable, Mr. Emmons?
Yes.
Mr. Williams?
Yes.
Would you get your signature?
Yep.
There's no particular order. A document labeled decision and order, which is an original document signed by the 3 members of this electoral board, will be marked Exhibit C 13013 and made part of the record. Any objection, Mr. Emmons?
No.
Any objection, Ms. Williams? The same document marked Exhibit C, an original of the decision and order, is being handed to Mr. Emmons. Would you acknowledge receipt?
I acknowledge receipt.
Ms. Williams, would you acknowledge receipt?
I acknowledge receipt.
Copies of the decision and order will be made very shortly, and they'll be available at the city clerk's office for anyone who's interested. I would encourage anyone to pick it up and try to understand the reasoning of this electoral board as they reach this decision.
You don't understand.
It should be available as soon as we conclude this hearing. We will have copies made. I believe our business is concluded, and as I said, anyone who would like to have a copy of the decision is going to be entitled to get one free of charge.